Hi, and welcome to another edition of the Trustcast Show. And we're happy to have with us today Nathan Cole. Welcome to the show, Nathan.
Zane, thank you. It's nice to be here.
So, today's guest left a clerkship at the Massachusetts Superior Court to build a trial practice that argued in front of the state's highest court, and the ruling could change how every subcontractor in Massachusetts gets paid. Nate, before we get into the case that's in front of the Supreme Judicial Court right now, take me back to the moment you decided you wanted to be a trial lawyer and not a desk lawyer.
Sure. So I grew up in Massachusetts. I was the first in my family to go to college, let alone to law school, and I'd had some interesting jobs over the years. I always thought I wanted to be a lawyer, but I really didn't know much beyond becoming a lawyer and really understanding the different types of law. After law school, I'd worked for a couple of firms in my summers that practice in the area of trial work. So I had a better sense during law school that I wanted to do that. That sort of seemed to me to be the kind of lawyer that I saw on television or just thought I'd be best suited for. I practiced for a bit right out of law school for the United States Department of Commerce. I worked in the ethics division for the Secretary of Commerce while my then girlfriend, now wife, was in law school in Washington, D.C. And I had a really good job with the federal government. I don't think I knew enough back then to appreciate that it was a cushy job, an interesting position, and I was pretty comfortable, but I don't do well with comfort. And I just couldn't sit still in that gig. I had taken a trial practice class with a state superior court judge while I was at Boston College Law School, and I liked that class and I liked that teacher. I reached out to that professor and said, I think I want to come back to Massachusetts at that point. My wife was toward the end of her 3 years in law school in DC, and I just felt like I was best suited for being in court. I didn't know enough to know that I probably could have or maybe should have stayed within the federal government system as a GS employee. And I decided I'm going to go back almost to the beginning and clerk for a superior court judge in Massachusetts. I felt like that would be a good way for me to reboot my career. But it was in the course of not being a trial lawyer and practicing law as an ethics attorney for the federal government that I thought I needed something a little bit more dynamic and challenging and that would maximize what I thought were my skills. And so I decided to give up that job, go back to Massachusetts or come back to Massachusetts and practice as first a law clerk for the trial court for the Commonwealth, and then started in earnest my career as an attorney that was in that space of trial work. So I had this sort of vision for myself, Zane, not knowing exactly what it would look like. As it turns out, I executed on the vision, whether it was the right idea or not. I guess it took some time to come to that recognition, but that's kind of what brought me from being an attorney back to Massachusetts and then practicing in the space of trial work. And then, as you alluded to, appellate level work, which is something that developed more recently in my career.
So let's talk about contractors and subcontractors and your specialty. So I'm going to pose some questions to you. So a subcontractor finishes a job, submits an invoice, and the GC, general contractor, for anybody who doesn't know what a GC is, just goes quiet. What do they do in the first 30 days? Well, I mean, when they go quiet, they like ghost them. They're not calling them back. They're not responding. They're quiet.
Well, the first answer is sort of the analysis. It depends, right? Like every lawyer answers a tough question. It depends. And it does depend in that instance on the type of the job, the size of the job, whether it's public, private. When we're talking about whether they've got certain obligations under the Massachusetts Prompt Pay Act, the Prompt Pay Act only applies to private jobs and pretty good sized private jobs. So the prime contract has to be, in the range above $3 million. If that's the case, then there are certain statutory obligations that a general contractor or an upstream party must do. Whether they do that or not, whether it's in that context or any job, depends. If they're a good contractor, if they're competent, if they understand what their legal obligations are, if they're solvent, right? Those things will inform what they do in response. What they should do, if it's a prompt pay job, and what they should do really depending on the
So what
contractor.
what makes it be a prompt pay job versus some other kind of classification?
Sure. So the Massachusetts Prompt Pay Act which was enacted, I think, around 2010, 2011, to protect downstream contractors from general contractors or upstream owners who were simply ignoring those payment requisitions and not doing anything. That statute was enacted because of that exact problem of lower tier contractors essentially being forced to fund and finance these projects by sitting tight and waiting to hear more about their requisitions for payment. The statute was enacted and it protects downstream subs on prompt pay jobs. So those are private jobs, not public. Doesn't apply to public construction. They are private jobs that involve fairly, substantial size jobs. So they can apply to residential projects, but they have to be more than 4 units and it has to be over $3 million. So when you're dealing in a project that's a pretty good size scope, decent sized job in the private space, then the Prompt Pay Act applies and the obligations for how to respond to payment requisitions come with the application of the statute to the job. If it's not
So
a
what do
prompt
they
pay
do?
job, what's that?
What do they do if they're in the prompt pay? Done this. What does a contractor do to kind of force the, or I mean, a subcontractor really, but they're a contractor too. What do they do to kind of force the GC to actually pay the bill? Because I've seen this so many times where a contractor, well, I mean, they can literally just finance an entire project off the backs of the subcontractors and just drive subcontractors, honest, hardworking subcontractors out of business.
Yeah, that's right. Or what they do is they leverage that situation to end up getting the subs to take a bath, to take a discount to get paid, and they're in a tough position, but for the Prompt Pay Act, because what are they going to do, right? They've submitted a payment requisition. The Prompt Pay Act requires the upstream party to respond to that payment requisition within a certain amount of time that's designated by the Prompt Pay Act. Let's say in the instance of a subcontractor looking to get a response from a general contractor to which they're entitled to because it's a prompt pay job. Prompt Pay Act requires the general contractor, requires that contractor respond to the payment requisition within 22 days. It's 15 days for the first tier. So when a general contractor submits a request for payment the owner has 15 days. Under the statute, every tier below that gets an additional 7 days to respond because, of course, the general has to take the request for payment from its subs and then go upstream and turn that around to the owner. And everybody needs an opportunity to review the requisition. Not every requisition they're going to agree to pay. Of course, there could be valid reasons for refusing to pay some or all of it. But what the statute requires the party to do that's upstream is to respond within that time period. So let's use your example of a subcontractor submits its payment requisition to the general on a prompt pay job. The general has 22 days to respond. It has to respond, first of all, in writing. That's an important distinction. And that writing with the rejection has to specify the reasons for not agreeing to pay the full amount. If they agree, then they have to pay, and then there's a separate time period within which they have to make payment. But let's talk about a situation in which they don't agree with the requisition or they don't bother to respond to it.
Yeah,
If
that's
they
what I'm thinking is somebody just says, "Oh, here's another damn subcontractor," and throws it over into the trash can.
Yeah, well, that happens, right? So they have to do three things. They have to respond within the time period, in writing. The writing has to specify the reasons, the bases for why they're not paying. They have to say whether it's a contractual reason, and they have to point to the reasons in the contract why the upstream party feels it is not obligated to make that payment. They also have to point to the specific factual reasons why they're not making the payment, and they have to certify that they've done something, that they're rejecting that in good faith. So they have to do it in writing and they have to have the contractual, the factual bases for not paying, and then that good faith certification. That's what they have to do in order to properly reject within the Prompt Pay Act. If they don't do those things, or in your example, they simply blow it off and ignore it, well, now the
Hmm.
subcontractor has a really interesting set of options, right? It has them essentially in a position where they have violated the Prompt Pay Act. They haven't complied with it.
Right.
The question then becomes, what does the sub do? If they're looking to set a bit of a sort of trap, well, they may do nothing. They may continue to do the work and they may continue to submit subsequent requisitions. And they may know strategically, they're in a really strong position. Now, they don't necessarily have the money. And so it depends on the sub. If the sub is a big sub, it may be able to continue to go forward and allow that upstream party to step in it, to put themselves in a position where they're in violation of the Prompt Pay Act. The Prompt Pay Act allows them to also suspend or leave the job, although that's not ideal in most instances. Walking off the job, even if you're statutorily protected from doing so, that doesn't get you paid. And in fact, that's most likely going to result in a litigation. So what a sub
So
should do in
that's
that
kind of interesting. Can I maybe I can jump off there
yeah,
just
of
to kind of
course.
dig into that. So if you're not getting paid, you're a sub, you're and you're mostly talking about commercial types of jobs, because those are the ones that are going to be big enough. So you're not getting paid, and you say, well, you've done everything that you need to do to comply with the Prompt Pay Act. You've requested payment according to the rules, and then they ignore it. And but at the same time, or they send you something, but at the same time, they expect you to show up at the job and complete the tasks that you were contracted for, but they're not paying you. Are you saying that you could actually get in trouble by not coming, even though you're not being paid?
Well, I think there's contractual and statutory protections in that instance, and that's part of what the Prompt Pay Act does. But they've got to deal with the pragmatic business realities of the relationship, of the dynamic of, what do you do? I don't think walking off a job is the best approach, even if it is something that the Prompt Pay Act provided some protections for. And that's one of the benefits of the Prompt Pay Act for the subcontractor or the lower tier party that's looking to get paid. But the reality is they've got themselves an interesting question that involves both business decisions and legal implications, strategic maneuvering. What they should do is talk to a lawyer and, as a team, figure out strategically what the next move is. Right? Is it to send a letter? Is it to escalate? You've likely got under the contract certain dispute resolution obligations that you have to follow. Do you jump right into filing a lawsuit? These are all considerations that contractors have to make because, of course, even if you've got a party upstream in a position where they have violated an act, the process of litigation is itself incredibly burdensome. And so
Hmm.
you may have somebody in a position where they violated the Prompt Pay Act, and you may be very well within your rights to litigate and to go forward. But of course, you have to make these strategic considerations that are in the best interest of the company, of the business, of a long-term relationship, perhaps. So there isn't a crystal clear answer about what you should do. Certainly, as a lawyer, I can advise about what your options look like. But then you've got to take into account all of these other considerations about strategically what's the smart thing to do for the business.
So I'm going to shift a little bit. So GCs push back on change orders constantly. They said, we never approved that. That's in scope or that's not in scope. How does a subcontractor protect themselves before that fight actually happens?
That's a great question, right? Because a lot of what we do as construction litigators is these things go all the way forward and you bring in experts. Many construction disputes necessitate expert witnesses. One of the things I've taken away from my time litigating these issues is that it's so expensive, sometimes necessary, but it's nevertheless expensive to go forward with these litigations. We've tried to reverse engineer a lot of that experience with my firm to try to guide clients at the claims process. So to answer your question, what could they be doing earlier? Certain construction claims are going to require experts to help develop them. And one of the things I think makes a lot of sense for contractors, if they understand how these claims will ultimately be litigated, they can themselves reverse engineer that and sometimes bring in an attorney, bring in an expert earlier in the process to put together a really well developed, well supported claim. If you're bringing a well developed, supported claim that has the backup and has the requisite answers to the questions that they're going to ask or anticipates the pushback and you put together a winning claim, well, you're going to be in a much better position to either get paid or to negotiate some sort of an outcome that doesn't result in litigation, which, as a litigator, as much as I do enjoy what I do and I like to fight, my clients don't love to be involved in litigation. And if we can avoid it by guiding them through a more comprehensive, strategic, just smart approach towards the claim itself, we oftentimes get them in a position where they're building a winning claim so that they can avoid the fight down the road.
So is there something that you could I kind of know the answer to this, but what can you put in your agreements? When the subcontractor calls you up, the GC calls you up and says, "Okay, we've selected you," and you're really excited because this is a great job. You really want this job. It's going to mean some financial security for your small firm, and so you jump on that and you sign some agreement. What can you do going into that? And you're already worried about, making sure that you get this thing negotiated and signed in. Um, you see this so many times, and so they agree to it, and sometimes they just agree to it verbally to start things off. What would you tell them about that kind of scenario?
Well, first thing I'd say in response to one of the things you just said is they do things verbally. Although you can have contracts that are oral and are certainly enforceable. As a general rule of thumb, I tell clients if it's not in writing, it didn't happen, right? Another way of looking at that is if it's not in writing, to prove that it happened is going to be more expensive. That means you're going to have to bring in witnesses, experts. If it's a he said, she said situation, lawyers do really well in those situations. They're going to have to fight about exactly what happened. What I say to clients when we're negotiating contracts, and I think that's where you're talking about sort of the risk management stage of things. First of
Right.
all, as a lawyer, I want to help the client get to yes. I want to help them be able to get the job, especially with the market right now. Margins are really tight, very competitive. Our clients need and want the work. They don't want a lawyer to come in and redline the heck out of a contract and have a general contractor or somebody upstream look at that contract and those revisions and think, that's great. You just wasted $4,000 on a lawyer. The answer is no, we're not accepting those changes. That's not valuable. That also suggests that the subcontractor either itself is unsophisticated or has unsophisticated counsel. So when I'm jumping in to help negotiate a contract, first I want to know from the client, how much do you want to push back, right? If
Right.
you'll sign anything, one, I'm going to still identify the real hotspots and the risk and try to prioritize and triage the bigger risks versus the smaller risks. We have enough of a sense, having done this for a long time and been in the construction world, knowing where are the areas that we can push back effectively and actually make some progress for you and get some value for you when you're paying me. I can mark up a contract by a powerful owner or general contractor on behalf of one of my clients. I can tell them before I even do that, they're not going to agree to this. I can put in a very favorable series of revisions, but if they're not going to accept it, you're just going to waste money on me and your time. So we don't want to do that. So what I'm going to
Right.
do is go through the contract with the client and talk about the things that keep the client up at night and talk about the areas of the contract that I think are unfair, that are excessive, that are not industry standard. And then talk about how you effectively and efficiently push back and negotiate with the upstream party so that you're protecting yourself, but that you're also keeping this thing on track to get executed, to get to yes. So some
Is that
really high level things. I've got kind of my top list of things that I would always insist or push to be included in the contract, and then a list of things that are maybe more wish list items but aren't necessarily deal breakers.
so is that so are you basically, rather than going and redlining a contract and throwing it back to the GC, in which case there's a high likelihood they're going to eliminate you as the subcontractor. So you're talking about either um, coaching the subcontractor into having a conversation with the GC and say, "Hey, these are the things that I'm concerned about." Is that how you would generally frame something like that?
Well, I'll always start with it depends. It depends on the relationship they have. Are they familiar with the other party? Who's the other lawyer involved? Is it somebody that I know that I can pick up the phone and just say, okay, let's figure this out, right? I know where your strengths are and weaknesses. I know where you'll give and where you won't. So I think so much of it is context. And once you have that context and you understand who you're dealing with as a client, what respective leverage they have, how much they want to push back, what's their risk tolerance. When we look at all of those things, then ultimately the contract negotiation is about effectuating those sort of business interests, the respective strengths, weaknesses of the relationship. All of those things come together and inform how aggressively we're going to pursue redlining a contract. But in an ideal world, we sit down, it's collaborative. All of the parties want to get a contract that avoids the real killers that result in clients spending extra time and money with lawyers. Things like ambiguity. Right? Ambiguity is the client's biggest enemy, biggest concern, I think, if they want to avoid litigation. Ambiguity is a great way to end up spending a lot of time and money with lawyers. Right? That's where they get put in situations where they thought one thing about the contract. As it turns out, the other side disagreed. Now you've got a fight on your hands. You're going to end up spending a lot of time with lawyers. So we want to eliminate ambiguities. Ambiguities in the scope of the work. The scope isn't that's not my area of expertise. So when we're talking about the scope of a contract, I'm going to turn that over to the client and say, this is yours. But you have to really understand what defines the scope, what consists of the capital C, capital D contract documents. You have to understand what you're signing. And that often means identifying other documents that the client may not think about as the contract. It could be the upstream contract itself, the prime contract. If the subcontract includes an incorporation clause, well, that means that they're also bound by another document that they may not have and may not even think they're entitled to get or to ask for. So first thing I want to do is make sure we have all of the contract documents, the specs, the plans, the prime contract, anything that could be part of the contract itself. And then from there, we're going to make sure those documents are understood, that we've walked the client through what they're signing up for, making sure there aren't inconsistencies in those documents. Because again, the ambiguities are that's the area where you're going to spend a lot of time on lawyers. So we want to eliminate those. And then we want to look at the risks that they can control for. That is, I don't mind my contract having obligations that flow to my client, provided that my client's, being paid for those responsibilities and can control for those risks. What I don't want, and I don't think is appropriate, although you see it a lot in the industry, is risk being dumped contractually onto the client who can't control for those risks. My client shouldn't be responsible for the conduct of other parties. It should be responsible for its own conduct, for its employees' conduct, for safety related to its work and its scope, and for those people working for it. So I think when those things align, you can end up getting to yes a lot more
So
easily.
that's kind of an interesting topic that maybe people outside of the construction industry don't think about. You said you have to be responsible for your own company and what you can control there. But sometimes in those projects, well, all the time in the construction projects, it's almost like you are linked to other subs and the GC in ways that you can't control because the schedule will dictate, and sometimes that can really hurt a sub. How do you deal with those kinds of situations?
Sure. Well, first of all, what I would say is you're gonna what you sign up for in the contract is what you're gonna own. So understanding what you're signing up for is critically important, and recognizing in that contract document if you're signing up for things that are out of your control based on the schedule that you can't control of others, then that's a problem, and you need to make sure that the contract has protections in place so that if the schedule gets thrown off based on another contractor for which you're not responsible, if the schedule gets thrown off because of poor management of the critical path by the general contractor, you have to make sure that the contract has protection in place for you to get additional time, for you to potentially have the right to bring claims for delays. If the contract eliminates those sorts of claims, well, then you're signing up for something that obligates you contractually, legally, to be beholden to obligations that you cannot account for, you may not be
Mhm.
aware of, to the point that you made. So the answer is understand what you're signing up for before you walk into a contract and obligate your company to things that you can't protect against, that you can't go back against them if there are damages. The reality of it is you're on the hook for whatever's in the contract. And so if you don't understand that, shame on you. You're going to be held accountable for it. And if you haven't been able to push back, then you have to make a decision. If you're dealing with an obstinate upstream party who's abusive or just using that leverage, you may still want to go into that deal. It may still be lucrative enough that it's worthwhile. You may be in a tough position where you need to keep your team occupied, not even to make money on that job, but just to keep the team together so that you can live to fight another day. But I think it's really important from a counselor's perspective that what we're doing is identifying those risks to the business so that the people that are running the business can then make informed choices. They may still make a choice that has risk. I mean, every construction project has risk to all parties
Yeah.
involved. It's a risky way to make money. It's not so much about eliminating the risk, it's about identifying it so that people are making intelligent, informed decisions as a business.
So I want to get into the Canestraro case, but before I go there, I'm going to do some rapid fire questions that just to kind of break things up. So you captain whale watching boats out of Plymouth before law school. What's the most memorable thing you ever saw in the water?
Uh, one time we came upon there was a boat adrift, and coming upon that, not knowing who or what was inside of it. As it turns out, it was just a rowboat that fell off the back of a larger ship and was just adrift. But when you're out there and you're seeing things, you're not really sure what's going to be coming. I was out on the water one time in Plymouth, and a tornado touched down, and you could visibly see it. We had to turn the boat around. It was a tour boat. People were going out for a little harbor tour, and we knew there was going to be some weather. And Massachusetts is not an area prone to tornadoes. We saw a
Right.
tornado touch down off in the distance. So, in the course of doing that, I started as a deckhand when I was 13 years old, and got my captain's license the day I turned 19, which is the earliest you can do it under the law for the U.S. Coast Guard. I got my license that day, and I was operating as a captain of my own boat the following day. So I saw a lot of things over the years. I had a great time. It was a lot of fun. I had an opportunity to also do some public speaking. I did the commentary on the way out of and the way into Plymouth Harbor. So you can ask me questions about the Mayflower 2 and the Pilgrims, and I can tell you all sorts of legends that I'd shared with people. Some of which I look back and question the accuracy of some of those stories I told, but saw a bunch of funny things and had a great time with some really hardworking people over the years. So as much as anything else, I learned what it was like to work a 12-hour day. And when I'm feeling like my job is difficult, I I think back to what it was like to make a living and what it's like for the people that are out there slaving away, untangling lines that are being used to catch dogfish and deal with sharks that you're pouring up from the bottom. There are harder ways to make a living than what I do. And whenever I'm feeling sorry for myself about what my job looks like, it doesn't take much for me to think back about the people that I worked with who were doing really tough work, dangerous work on a daily basis.
So skiing at Ragged Mountain or hiking? Which one do you pick if you can only pick one this weekend?
Well, this weekend I'll pick hiking. The skiing's probably not that great up at Ragged. Ragged's a fun place. It's a small mountain. It's really community driven, and I've got a great group of friends that live around me up in New Hampshire, where we are blessed enough to have a second home and a little escape that I get together with on the weekends. And so either way, it's an opportunity to hang around with great people and get away from other things and tune out, shut off our phones, and just be present with our kids and our friends. So I'll take either, but given the weather and where we are in the season, this is kind of a this would be a hiking weekend. Although this time of year up in New Hampshire, I'm not there because there's bugs and there's mud and there's not snow. So ask me in
So
a couple months.
where the hell is your New England accent?
Oh, do I not have it?
I don't hear it. I don't hear it. Not like I know a bunch of people in Boston. And
It can come back with a couple few Sam Adams. It'll come
okay.
back, and depending on who the jury is, I can bring out the accent. But I'm born and raised in Massachusetts. But I did growing up working on the boat. I had a really strong Boston accent, and there's a guy that was the captain ahead of me who gave me an opportunity to do some public speaking, and he said they can't understand anything that you're saying. Yeah, and you got to lose that Boston accent. And so I had it. It'll come back here and there, but I bounced around. I lived in New York City, lived in DC. I kind of fine tuned it. Sometimes I wish I still had it because my brothers have it, my parents had it. I come from a long line of folks that live in Massachusetts, but it was easier to communicate with people from all over the world if I could shut that accent off.
So construction client calls with a crisis on Friday at 5 p.m. What's the first thing you do?
Friday at 5 p.m. I probably curse because it's Friday at 5 p.m. But I take the call, and I say, well, what's going on? If they're calling me at 5 p.m. on a Friday, they need me, and that's what we signed up for, right? That's the gig. And so I say, what's going on? tell me what's happening. Where are you in this? How time sensitive is it? And we understand the situation. We assess what needs to be done next. And we just get everybody to take a breath, slow down, and let's think strategically about next steps.
One clause every contractor should add to their subcontracts right now.
That's an easy one. Attorney's fees. If you have to chase, you need to have your attorney's fees paid for by the other side. So you at least have that leverage. Whether you get them or not is a different question, but not having them means how do you spend money on a lawyer to fight over $50,000 if it's going to be a real fight and you're going to end up spending, 40. That's not a
Right.
good bet. So having an attorney's fees provision in a contract is a no-brainer.
Okay, so walk me through the Canestraro case. Plumbing sub, nearly $1 million, years of fighting. What actually happened on that job?
Sure. So that was a job in which Canestraro did a fantastic job. And I mean that not just because I represent them and I think they're a heck of a contractor, really one of the best subs, the biggest mechanical sub in New England. They did a great job. There was no claims against them. They weren't found to have done any defective work, nothing like that. What happened on that job, however, is that the job was somewhat poorly run from our perspective. That is, we were showing up and there was trade stacking, and we're going down the hall trying to do our work. And because of the management of the project, we weren't able to do it. There were change orders that were submitted and, in fact, agreed to and paid on that job. And at a certain point, when you have a number of change orders again and again and again, even though they're getting paid, that doesn't fully capture the loss of productivity. And so
Mhm.
toward the end of that job, Canestraro recognized that it didn't make the profit that it should have made on that job. And it had to ask itself, well, why? And what they recognized was that there were a number of impacts as a result of the management or mismanagement by the general that resulted in a real lack of profit and productivity. And so Canestraro put together a lost productivity claim or a lost productivity, a cumulative impact change order. Canestraro
That
is really
sounds like
sophisticated.
a tall order to execute. So tell me what happened.
Yeah, it is a tall order. That's not your run of the mill change order. In fact, oftentimes with a lost productivity claim, you don't really recognize it until you're at the end of the job. You know things have been going poorly or they've been inefficient. There have been these stop starts and mobilization or demobilization. You felt it, you've kind of lived it, but you're getting the change orders approved. And that's what happened here. There were 40 or 50 or so change orders that had actually been approved and paid by the general and the owner to Canestraro, but that didn't fully capture the cumulative impact. And so Canestraro, which has a great in-house counsel and a legal team itself, they recognized what was going on. And through that attorney, in-house counsel, put together with the help of an expert witness before litigation, long before litigation, put together a pretty comprehensive change order for this lost productivity. And they documented it and they had an expert behind it. And given the nature of that change and where you can't find a measured mile, a sort of period of calm on a job site that you can use as a frame of reference, they
Hmm.
use the expert and other documents and certain factors, the MCAA factors that apply to mechanical subs. They're similar to the NECA factors that apply to electrical contractors, but they use these factors to essentially ballpark with a fairly high degree of accuracy the amount of the damage, and they put that all together. And unlike every other change order throughout that job, which had been more of an iterative, collaborative process, in this instance, the general contractor responded with a letter that simply said, "No, we're not paying it." If I recall correctly, they said, "If you continue to pursue this, then we'll come after you legally," which was not the right way to respond to a change order. What they didn't do was reject that change order with the required certification of good faith. That is, the Prompt Pay Act, as you remember earlier, requires someone to reject a change order or a payment requisition with the written contractual and factual bases for why they weren't paying. Columbia actually did do a pretty good job of outlining those factual and contractual arguments. We disagreed with them, but they did at least do enough of a job to, I think, satisfy the requirements of the Prompt Pay Act with regards to those requirements. What they failed to do in that rejection, however, was to include the certification that the rejection was being made in good faith. That was fatal because that certification under the Prompt Pay Act is found by the Massachusetts appeals courts, both the Supreme Judicial Court and the Court of Appeals, to be more than ministerial. It was fatal to the rejection. After that, the change order was improperly rejected. Canestraro put in the requisition. Same thing happened again. There was a rejection, but they didn't certify the rejection as having been made in good faith. They didn't make the payment, and then they just waited. And Canestraro filed suit. It sought to put a mechanics lien on the project, and it sought to pursue its nearly $1 million in lost productivity or cumulative impact changes. It then, because the contract required arbitration, the case was stayed in the Massachusetts trial court, the Superior Court, pending the arbitration. We went forward and then arbitrated the case for months and months and months, conducted discovery, and then moved for summary judgment. And at the time that we filed the motion for summary judgment, we argued that they didn't properly comply with the Prompt Pay Act. We made some other arguments as well, but we said we're entitled as a matter of law to be paid for the $1 million or so in lost productivity change orders. Canestraro argued, no, you're not. They raised all sorts of arguments why they shouldn't have had to have paid, both contractually and factually. What they hadn't done at that point, however, is to make the payment. And so they were holding on to the money, forcing Canestraro to litigate these issues. Canestraro, unlike a lot of other smaller subcontractors that couldn't have actually gone through this
Right.
years of litigation, they were able to bring the fight to the general, and they did. We moved for summary judgment, and at that time, a case came down in the appeals court, the Tachi decision, in which the appeals court, for the first time, issued a ruling that said, when you do things like failing to certify the rejection in good faith, that's not just a trivial ministerial failure. You're violating the Prompt Pay Act. And the arbitrator correctly ruled that the failure to certify the rejection in good faith was a violation of the Prompt Pay Act. And he did correctly order them to pay the full amount of the change order. And they did. The problem, however, is we said that they didn't pay the amount that was deemed approved by failing to reject the change order properly before they dragged Canestraro through litigation. They held on to the money. They forced Canestraro to file the lawsuit. They forced Canestraro to litigate it. Then they forced Canestraro to move for summary judgment. They opposed the summary judgment motion. And only after losing the summary judgment motion and being ordered to pay did they finally turn over the money. The problem is that it didn't end there. We say it should have. The arbitrator allowed their motion to bring a claim against Canestraro. Prior to that point, they had no claim. They had defenses.
So
They
they
had
tried to
new
claw back the money. How, I don't even understand, how is that a thing? Why would an arbitrator allow, even the consideration of something like that?
Well, because there can be legitimate reasons why, notwithstanding the failure to have promptly and properly issued a rejection, they still may have arguments that they shouldn't have to pay that amount. There could be fraudulent change orders or requisitions that were submitted. That wasn't the case here, but you can see a world in which somebody blows the prompt pay deadlines, but they have viable, bona fide arguments that they shouldn't have to pay that amount. Our position in Canestraro is not that you shouldn't be able to advance those defenses. It's that you shouldn't be able to have your cake and eat it too. That is, if you violated the Prompt Pay Act, there have to be consequences to that. Otherwise, the Prompt Pay Act doesn't mean anything. We say those consequences are you turn the money over and then you can litigate those defenses or any claims that you have. What you can't do is sit on the money, drag them through litigation, and only when ordered after losing a summary judgment motion to pay should you then be able to, turn that money over and start litigating the case all over again. Had they paid the money before they answered the complaint and raised these affirmative defenses, raised their arguments against why our change orders were legitimate, and they turned that money over, I think they could have preserved their defenses and their arguments. But it's the order of operations that's so critical. Now we have the benefit of case law that came down, and this is the kind of wonky part about the Canestraro case, is that as this case was going forward in arbitration, and as the arbitrator was making rulings, the case law was evolving and developing and fleshing out some of the import of the Prompt Pay Act while we were litigating our case. And so what happened was the arbitrator correctly found that they had violated the Prompt Pay Act and correctly ordered them to make payment for having violated it at the summary judgment stage, where I think the arbitrator made a mistake and exceeded his powers in violation of mass law, was that he then allowed them to make the payment pursuant to his order and bring a claim for recoupment to claw that money back. I think had they brought the claim at a different point in time, but only after they made the payment, they could have preserved their right to bring that claim of whether you want to call it recoupment or sort of disgorgement of that amount. There's a world in which the Prompt Pay Act allows for that and contemplates it, and I think that's totally above board and fair and consistent with what was contemplated by the legislature when it enacted the Prompt Pay Act. What I don't think is acceptable, and where I think the arbitrator exceeded his powers, and that's the argument we made to the SJC, was this sort of order of operations. That is, to force them to litigate, to lose, then to make payment, then to be able to bring claims to get the money back. We say that's no good. That's essentially rendering the Prompt Pay Act meaningless. And that's the fight that took place. So we ended up having to then arbitrate the claims. The arbitrator allowed them to raise defenses under the contract and factual arguments. We went through the rest of the arbitration, at the end of which the arbitrator decided that a portion of the nearly $1 million change order had been sufficiently proven, but that there was a certain percentage of it which they found had not been proven, and ordered that chunk of money returned. Now, we say that we successfully established damages for the full amount of the change order. The arbitrator disagreed. Once the order came down requiring my client to return a portion of the $1 million that it had been awarded after having prevailed at summary judgment, our clients were not happy with that result. Notwithstanding that we established almost $500,000 in damages, they didn't want to have to give back any amount, especially where they had been the victim of a Prompt Pay Act violation. And the client and myself and my partner, Ross Wecker, who was really instrumental in prosecuting these claims at arbitration. I jumped in and did the arbitration with another colleague, but myself and Ross and counsel for Canestraro just discussed the next steps, and we decided we were going to take our shot and move to vacate the arbitrator's award at the trial court level, simultaneous with Columbia moving to enforce the award. When an arbitrator hands down a decision, the decision itself doesn't have any teeth if the parties are fighting about the validity of the decision. You have to bring that decision to the trial court and get an order.
So ultimately, I want to change. I want to go on it in a different direction too.
Okay.
But I want to wind this up so ultimately, what happened there?
So what happened was the trial court decided to vacate the arbitrator's award. The trial court agreed with us and found that the arbitrator had exceeded his powers by allowing Columbia to prosecute claims without having first paid before it advanced those claims. And so it found that order of operations, the law is you've got to pay to play. The trial court found that they litigated, and they only paid after fighting. And the trial court said, that's no good. That's exceeding your powers. And then the Supreme Judicial Court, on appeal from that trial court decision by Columbia, the Supreme Judicial Court reached down and said, we're going to take this decision and we're going to weigh in. And in fact, that's what they did. So we argued before the SJC on February 4th, and it raised a host of questions about sort of how the Prompt Pay Act works, the standard for vacating an arbitrator's decision. Right? It's a very high standard. It's got to be exceeding their powers in state court. Federal court, the standard's a little bit different, articulated differently. And then there's this other question of the arbitrator made a decision and a subsequent SJC decision came down that the court's reconciling that retroactive application of a later decision and how that squares with the arbitrator's decision. So there are a lot of kind of moving parts that implicate not just construction, but civil litigation and civil procedure as a whole. And that's the SJC case of Canestraro versus Columbia. We're waiting on the decision now. It should be coming down any day now. We're expecting it in the next couple of weeks or months.
So this sounds like this will be precedent setting.
Absolutely. Yeah, I had a funny conversation. I've got two daughters, and they were kind of following along with this. And my younger daughter asked my older daughter, so is dad going to be, making new law. And my daughter said, well, yeah. And I said, well, no, no, I definitely am. It's just a matter of, which side of that law we're on. I'd like to be on the winning side, but
Mhm.
either way, it's a really significant decision that will clarify for all practitioners in Massachusetts, certainly the application of the Prompt Pay Act and how it works with regards to claims. But in a larger sense, it's establishing law with regards to the standard for vacating an arbitrator's award and the retroactive application of a decision an earlier arbitrator's award. And there's a lot of things here that I think will clarify areas that all of us that practice in this space are looking forward to getting clarity on.
So I want to ask you about business divorce because so it's I have so many questions, but we're not going to get to all of them. Like I said at the beginning, so this is another area that you specialize in, business divorce, and I never really thought of that phrase in that way. But tell me about that. So someone's been a majority or minority owner in a business for 10 years, and they're getting frozen out. Their salary just got cut, they're being excluded from decisions. Is that actually illegal?
Well, yes. Ours, yeah. I mean, you've got certain. So a couple things you mentioned. One, sort of the salary being frozen out, like that person could be a shareholder that has certain fiduciary obligations to the company and to the other shareholders, and vice versa. And then separately, that shareholder may be an employee of the company, right? So there's a mix of things that are happening. But at a high level, when you're an owner of a company, you've got fiduciary obligations to the company and to the other shareholders. And when those shareholders are doing things that are in conflict with those obligations to the company and to one another, there can be fights, and they bring us in. So it can be a freeze out situation where the majority shareholders are not showing the minority shareholder the requisite level of good faith and fair dealing and transparency that they owe them. And in that instance, you've got a fight on your hands, and you're going to try to establish either that somebody is breaching those duties or not, depending on which side of it you're working on.
So the majority owner just they'll come in and they'll make some okay, I'll buy you out, but then they want to offer really like 20 cents on the dollar of what the share in the company is worth. How do you combat that?
It's an interesting question, right? So one, it's going to be, what do the documents say? How do the documents control what those shares are worth or what the process looks like? Are they following the processes? Because the number of times we've seen folks that have been running businesses but have never really looked at their documents and don't understand what those documents obligate them to do, that happens a lot, right? They sort of shoot first and ask questions later, and they get themselves into trouble instead of consulting with counsel before about how to do this. You can remove a shareholder. There are ways to do that statutorily under the contract, but you have to follow those. And when they don't follow the obligations that are set forth in the various partnership documents, that they run into trouble, and you litigate over whether they've done those things correctly or not, whether they're pretextual, right? Whether they want to get rid of somebody because they don't want to share any longer. They don't have a good faith reason to get rid of them, so they create one. And our job is to, fight for the respective shareholder depending on what side of it we're on. Sometimes we're fighting on behalf of the minority shareholder, and we're arguing that they're getting frozen out, that there are opportunities that belong to the company, that belong to that shareholder as well, that some of the shareholders are diverting. That's something we have to jump into and prove. And so, you look at the facts, you look at the circumstances, you take depositions, you get documents, you track down evidence of damages. You may want to bring in, as we often do early, a forensic accountant to understand how much money are we fighting about. What's the real value of what we're doing here, so that we can inform the client about the potential upside of their claims. Nobody likes to get into a situation where they're involved in extensive, expensive litigation, and it turns out there's no damage, right? There's no there. So we're trying to do a bunch of things at once as early as possible. And that's all in the name of guiding the client to making informed decisions that make sense financially. I don't look at myself as a sort of return on investment. It's not a guarantee when you're litigating, but I certainly want to make sure that before we go forward and we're giving advice and counsel to a client, that we're doing it holistically and comprehensively and in an informed way. So the name of the game is trying to figure out as much as you can as early as possible, and then guiding the client strategically through the tough decisions they're going to make in the course of not just the litigation, but the exit strategy from the company, or pushing somebody out, but doing so in a way that saves money and stops fighting if you can do it. And then other times you can't, and you have to litigate these things. And so you have to prepare for trial, not preparing to settle. Too many lawyers prepare to settle and think of themselves more as litigators, not as trial lawyers. We're really understanding that these cases, if they go to trial, and most of them don't, you have to have done the work earlier and really looked under every rock in a time when you've got an opportunity to do so in discovery. If you decide that, oh, shoot, we're not going to settle, we have to get ready for trial, and it's too late in the process, then you're going to try the case blind. And that's not an optimal way of moving forward in that situation.
So are those the two areas that you specialize in, is construction law and then business divorce?
Those are
Do you have
my
other areas?
Yeah, those are my two sort of specialties and focus. The firm also does a transactional work for on the construction and things. So we, alluded to a lot of construction contract negotiation, and then we do
Mhm.
a fair amount of employment risk management counseling for companies. So that dovetails with our work representing contractors. Contractors have employees. Employees, can result in problems, and employers need the guidance to make sure that they are properly um, you know, monitoring what the employees are doing, that they've got good handbooks and policies and protocols, and that if they have to separate from employees, that they're doing so carefully and within the letters of the law. So it's construction risk management and litigation, it's business divorces, and then we have a big chunk of our practice is employment risk management and litigation. Those three are kind of our bread and butter areas.
So what does Cole Law Partners look like 5 years from now?
Oh shoot. Well, we started 6 months ago with four of us, and no staff. That was maybe a mistake not to have staff as we started. There's nothing like trying to file something on your own as an attorney when I haven't, understood the system of filing documents to recognize how valuable a really good legal assistant is. So the first
Hmm.
thing we did when we started is recognize we needed help, and we brought aboard a billing person, a woman that I'd worked with in the past to help us make sure we're getting paid, and then brought in an outstanding executive legal assistant that we'd worked with who can just help keep the trains running. We've gone from four lawyers and no staff in October of 2025 to we just hired our 10th lawyer, and we have four other employees. So we're at 14 people now. So if you'd asked me, 7 months ago, 8 months ago, if we'd be here, I don't know that I would have been able to predict it. I think where we are right now and where we want to be is a really well run boutique firm, and not small, but boutique, specialized. They're providing really exceptional client experiences, and that's kind of a concept that we've focused on. I think as we decide whether we want to scale or not, it's going to be in the name of making sure that we're providing excellent, comprehensive experiences to our clients that have been so loyal to us and supportive of this endeavor. And if we do grow, it's going to be deliberate and intentional. That's the biggest thing that I would say. I don't know if we'll get bigger, but I do know that we don't want to compromise on the things that have got us to this point and that have made us effective and successful. And so we're really focusing right now on fine tuning the operational end of things so that as we go forward and grow, we're able to replicate what's worked so well and not sacrifice it in the name of growth for the sake of growth. I've seen that happen. We don't want to do that. So it's really about sort of an intentional growth strategy that allows us to replicate the experience, lean into the things that I think we're doing well and have always done well, embrace technology, AI, hybrid work environments. I know that some firms and companies are, I think, in a somewhat reactive way, pushing people back in the office. I love getting together with my colleagues in a physical space, but I want to do it intentionally, and I want it to be in the name of making sure that our people are feeling good about what they're doing, that they're energized, that they're well rested, that they're able to collaborate so that we can deliver an outstanding customer experience. So, all of those things kind of are meant to be intentional in the name of providing better service, reducing turnover, and also making sure we've got a nice, clear succession plan so that what we're doing now can be replicated by the lawyers that are coming up from behind us.
So do you have some younger lawyers that are coming up in your firm?
We've got outstanding junior attorneys that are making this possible. We were lucky enough to have one junior lawyer, senior associate now, come over from a firm where we had worked together before. He joined us after we left and has really just jumped in, hit the ground running. He's a really just an exceptional young attorney in person. And then we've got three other attorneys that have joined the firm over the last few months that came over with varying levels of experience in private practice, and one was a law clerk for the Superior Court. But we want to make sure that we are able to give them an opportunity to grow at the right pace. You got to push them out of their comfort zone sometime, but we're trying to find that balance between asking folks to step up, but not abandoning them and having them feel like you've got to figure it out. I think figure it out is a bad way to get people up to speed and have them feel as though that they're learning the right way. So we're working on that balance, and it's a work in progress. But we have a system set up where we've got a partner assigned to every associate directly. They're primarily working with that associate, maybe 80% of that associate's work. And then we're also giving the associates an opportunity to cross over and get some experience in the other areas. Some of them may want to do a little bit of employment work, but also want to get an opportunity to learn in the construction space. And we're able to give them those opportunities to learn from other people. And frankly, I think it's so important as a junior lawyer to see how other senior folks go about doing something. I think that's a really healthy way to grow. Recognize that there are multiple ways to get a good result for a client, and you've got to do it in a way that's authentic to you.
So, if someone is listening here today and they're in construction, and they have a dispute, or if they're in business divorce, or I mean, if they're having a business divorce, nobody's in business, they're having some sort of issue and they want to discuss that over, or it sounds like even if they're in one of these fields and maybe they're interested in joining your firm, what's the best way to get in touch with you?
For the most part, what we found is people reach out to us through LinkedIn or other, common connections. As a small firm that was launching, that appeals to a certain type of potential candidate. And our lawyers are people that have come over that have options. And I wouldn't want to hire somebody that didn't have lots of options. So people reach out to us, they kick the tires on us, and they do their homework, which is what we would expect. By the time that the people that we've hired have connected with us, they've done their homework, they're curious about what we're doing and why, or if it is different from other firms as we like to think it is. And it's been a very organic sort of process of getting to know one another, of checking references to make sure not only that the person has the talent and the drive, but really is the sort of right fit in terms of integrity and values. And as a small company that has people that have worked together at other places and know one another, to onboard new people, it's important that we're a good match for them and that they're a good match for us. I think it's just as important that when someone's considering a big career change and coming to work for our firm, I want to make sure that we can put them in a position to be successful, and are a good fit for them. And we're not necessarily a good fit for everyone. So I think it's
Right.
just as important that they and we recognize or identify whether we're a good fit for the employee, for the attorney, as much as it is important that we look at whether they're a good fit for us.
So your geographic location, is it just within Boston or the greater Massachusetts area, or are you looking to spread out, or are you spread out further?
Yeah, so all of the above. So we're primarily practicing in Massachusetts and in Metro West Boston. We really practice throughout the Commonwealth. The work that we do brings us to every town in the Commonwealth, every court at both the state and federal level. I'm licensed in New Hampshire. One of my partners and one of the other attorneys is licensed in Rhode Island. We have a growing Rhode Island presence as well. So it's primarily Massachusetts with maybe 20% Rhode Island, 10% New Hampshire. Although that's fluctuating now, and as we're sort of growing and our clients, which are really driving this, are doing work across the state lines, we're growing to make sure that we can service the clients that are operating in other areas of New England. But we are strictly in New England. There are times that we're brought in as national counsel and we hire local counsel so that we can litigate on behalf of our Massachusetts or Rhode Island or New Hampshire based clients, but do so in other parts of the country. When we're in those instances, we bring in trusted local counsel that we're familiar with through various trade organizations or legal organizations that we've come to meet other good lawyers that approach things the same way as us.
Well, Nate, thanks for coming on the show. I really appreciate it. It was an interesting topic.
I appreciate it. Thanks for having me.